The Crown has abandoned its case against Vice-Admiral Mark Norman. The former second-in-command of Canada's military was facing a breach of trust charge, and today the prosecutors say they found new information which made them believe they couldn't secure a conviction.
General, good morning. Good to see you. Thank you very much. Thank you.
We decided alone, no political interference whatsoever, that we couldn't make the charge.
While I'm relieved to be exonerated of any wrongdoing, I am disappointed it has taken this long.
We still have lots of questions about why the government was so afraid of the truth coming to light.
We also heard some allegations of direct political interference of the Prime Minister's office.
So you don't put your finger and try to weigh in on the scales of justice.
The process involved in a public prosecution like this is entirely independent of my office.
Vice-Admiral Norman has been through a great deal. His family has been through a great deal.
I look forward to my immediate reinstatement and a return to serve in Canada.
We begin the show this evening, though, with a reminder of what Vice-Admiral Mark Norman's case is all about.
I'm anxious to get to court, get this dealt with as quickly as possible, and get back to serving the people of Canada.
The Mark Norman saga dates back to 2015, when the Conservatives were still in power.
The reason we're not going through a normal competitive process is we don't want to take a long time on this.
The Harper government awarded a $700 million contract to Quebec's Davie shipyard to convert a commercial ship into a Navy supply ship. It was an unprecedented deal because the feds changed the rules so they could award the contract without any competition. But Davie's competitors had their own proposals they wanted to pitch.
We think we have a better, faster, less expensive alternative with much less conversion risk.
So in November 2015, the new Liberal government quietly agreed to pause and review the deal. Treasury Board President Scott Bryson argued the loudest for the timeout, according to court records. It didn't last long, though. Information was leaked to James Cudmore, then a reporter at CBC News, that the contract was on ice, and that sparked outrage in Quebec.
The ship is there, the workers are there, it's an important project, and it has to move forward as planned.
The feds backtracked and quickly approved the contract, but furious over the leak, they ordered the RCMP to investigate. Enter Vice-Admiral Mark Norman, the military's second-in-command. The RCMP alleged that for over a year, he leaked cabinet secrets to unauthorized parties, including Davie, to help the shipyard secure the contract. In January 2017, Norman was suspended from his job.
I support the Chief of Defence Staff in the decision that he took.
And more than a year later, he was charged with one count of breach of trust.
This has been a really difficult time, and it's going to continue to be a real challenge.
Norman vehemently denies any wrongdoing, but the case has led to many questions. Why did the Conservatives change the rules around procurement? And why were the Liberals hesitant to let Davie have the contract? Those questions all set the stage for a high-stakes political drama.
Norman's trial was scheduled for August on the eve of the federal election. In pretrial hearings, Norman's lawyers argued the case was politically motivated and fought for months to access various government documents to prove it. Then, Liberal MP and former Canadian Forces Lieutenant General Andrew Leslie announced he wouldn't run for re-election, and reports surfaced that he would testify in the trial for the defense. A few days later, prosecutors announced they were staying the charge against Norman.
We decided alone, no political interference whatsoever, that we couldn't make the charge.
I think it's time to say sorry to him.
Ultimately, I look forward to my immediate reinstatement and a return to serve in Canada.
While lawyers on both sides say today's decision to stay the charge was made independently, Mark Norman's lawyers have criticized the government throughout this case. Was there a bias against Norman from the government, and should the government take any responsibility for its role in this trial? Marco Mendicino is Parliamentary Secretary to the Minister of Infrastructure. Aaron O'Toole is the Conservative critic for Foreign Affairs, and Charlie Angus is the NDP's ethics critic. They all join us from the foyer of the House of Commons. Hello to all three of you. Thanks for joining me today. I really appreciate it. No problem. Mr. Mendicino, I'll start with you. Vice-Admiral Norman today referred to the alarming and protracted bias of perceived guilt across senior levels of their government. Was there bias against Mr. Norman in the PCO or in the government?
No, there was not, and I would echo the statements that were made by Vice-Admiral Norman's lawyer today, which is that this was a trial that was carried out without any political considerations impacting the outcome of this trial. Indeed, she described it as being unassailable by any political considerations, and this is indeed what Canadians would expect. We have a justice system which is world-renowned, which enjoys the confidence of Canadians because we have rules and principles in place, and today is an affirmation of that.
Ms. Hennon actually specifically said that there wasn't political interference, but she also made a point right after saying that of saying that the government was very much present at the table, that there were 7 or 8 lawyers at all times, and she pointed out that the PCO and other departments in government made a distinct decision to litigate rather than provide documents that the defense had asked for, to litigate and essentially, she said, draw the process out for 6 months. Is that maybe not political interference, but political involvement?
No, and Ms. Hennon's a very experienced defense lawyer, and she would understand very well the defense disclosure process. I myself have participated in many trials, and these applications which were put forward involved third parties, in other words, parties outside of the traditional Crown and the defense. It involved other branches, and in the course of producing those documents, and indeed thousands of documents were produced to Vice-Admiral Norman, there needs to be a careful vetting to protect national security, to protect solicitor-client privilege. If the opposition is going to say we need to uphold the rule of law, that also means those principles as well.
Mr. O'Toole, as Mr. Mendocino points out, Ms. Hennon did say that today's stay shows that the system works, that there was not political interference. Would you agree?
No, Mark Norman shouldn't have required hiring the best lawyer in the country to defend him. This goes back to the first Liberal cabinet meeting where Scott Bryson tried to interfere with an ongoing naval contract. The Prime Minister's office then hired the journalists that broke the story on the leak from the cabinet meeting. Michael Wernick did an investigation, found 73 people knew about the leak, but only Mark Norman was initially charged, and he was charged a year after the Prime Minister said he would be charged. So this has been political from day one. I'm very proud that DPP made the right decision to stop or to stay the charges. But the very fact we're having this discussion, Vashi, goes back to the first days of the Trudeau government, where the old habits of the party influence trying to change things, potentially at the behest of supporters. This should concern a lot of Canadians, and the fact that a fine Canadian's name was dragged through the mud for over 2 years, it's shameful, and people are demanding answers.
But he was ultimately cleared, right? And he was done so through the justice system as it works right now. And she was unequivocal. Ms. Roussel, who our viewers will know through our discussions on SNC as the Director of Public Prosecution, was unequivocal as well. There was never political interference.
Who made the decision after Mr. Wernick told the Prime Minister there were 73 people aware of the leak? Mr. Norman was not at the cabinet meeting where the leak occurred. Why the decision to pursue him? There's a lot of questions here, Vashi, that go before there were charges laid, before the DPP got involved. They are the finest prosecutors, and they realized there was no prospect of conviction. There shouldn't even have been this scandal, but for the interference of the early Liberal Trudeau government.
Mr. Angus, your party is calling for an independent investigation. Same question to you. Ms. Hennon and Ms. Roussel say there was no political interference. What else would you like the investigation to ascertain?
Well, I think Canadians need many answers into why a career naval officer who served this country was treated in such a shabby fashion. This goes back to a Liberal cabinet meeting. What was the role of Scott Bryson? This was about a very lucrative shipbuilding contract. There's allegations that this was the political interference to help political friends of the Liberal Party. Why was Admiral Norman the only one taken out and treated in this manner? And the other element that I think, to the credit of the Director of Public Prosecution's decision not to go forward, is when you have a former Canadian general like Andrew Leslie stepping up to testify on behalf of Admiral Norman, I think that sends a real signal of his credibility. But what's staggering is that he was a star Liberal MP. So we now have Andrew Leslie who's willing to testify against the government direction, following the former Attorney General who stepped down, following the former President of the Treasury Board who stepped down. We have never, ever in Canadian history had such powerful members of a government step out over an issue of interference in the rule of law. So I think we need an independent investigation to explain to Canadians how this trial got off the ground, what was the role of the government in trying to help friends of the government in terms of getting these contracts.
Mr. Mendocino, why was Mr. Norman singled out, and would your government agree to an investigation to figure out what the reasons for that are?
Well, I begin by underlining that the decision to investigate, charge, and eventually stay the charges against Vice-Admiral Norman were made by the RCMP and by the Public Prosecution Service of Canada, respectively. I know that the opposition is going to try to relitigate this in the court of public opinion, but really what they would have you do is say, don't believe Mary Hennon, who defended Vice-Admiral Norman, and certainly don't believe the Director of Public Prosecution Service of Canada, believe Andrew Scheer, believe Aaron O'Toole. Well, I'm sorry, that is not the way that you... That is not the way that you, well, listen carefully to what Vice-Admiral Norman's counsel said. And when you look very closely at the way that this matter was conducted, indeed, it was carried out independently. The decision to investigate, the decision to charge, the decision to stay those charges were all carried out independently. That is a fundamental hallmark
but your government
of the way
was
our
at the
court
table.
system works.
Your government was at the table. Your government had the opportunity to provide those documents at the earliest possible point to shorten the amount of time that this man had to endure what he endured, and the government didn't.
By necessity, and at all times, there were ethical walls to ensure that the prosecution was carried out responsibly and independently with due regard to the disclosure obligations of the Crown in keeping with our need to protect national security and solicitor-client privilege. Vashi, that is the way prosecutions are carried out in this country.
Mr. Mendocino, is there a cap to how much the government will reimburse Mr. Norman for his legal fees?
Well, that's a decision that was communicated today by the Minister of National Defence, Harjit Sajjan. I certainly would not want to usurp either him or his department's decision with regard to that. But I think that is indeed, again, another hallmark that what we have had here is a fair process.
So no answer on whether there's a cap or not?
Indeed, that will be a decision which will be communicated by the Minister and his department.
Mr. O'Toole, should Mr. Norman be reinstated to his former position?
Absolutely. We've called for that immediately. In fact, what's funny, Vashi, a couple of weeks ago, the Liberals voted against covering Mark Norman's legal fees. Normally in a court finding, if you have to pay costs and the fees of the other side, it's when the court has found against you. So,
to be fair, the charges hadn't been stayed at that point, though.
The charges were not stayed, but the Liberal MPs that voted against that were supporting the actions and decisions of the Prime Minister's office. I say again, the initial investigation here was done by Clerk Michael Wernick, who is no longer working for the PMO. We saw that in the SNC scandal, or the PCO. Why was Mark Norman singled out after this investigation had 73 people? Why did they hire the CBC journalist who first broke this scandal? There's so many questions that go right to the root before the DPP and the lawyers were involved. The early decisions of the Trudeau government should concern Canadians.
What about the decisions of the RCMP? The prosecutor today was unequivocal that further evidence provided to the prosecution, some from applications for records that were not part of the investigation file, and some volunteered by the defense are what swayed them, what convinced them to stay the charges. Are you concerned that the RCMP was not made aware of that or didn't have that information and yet still proceeded with this investigation?
I am concerned, and I'm also concerned by the fact that we may not still have all the information, both the defense, the RCMP, because it came out at the pre-trial that they were using code words to not disclose Admiral Norman's name. He was called Kraken and other code words to hide, essentially, documents related to this case and his defense. The last
Although
time
they claim they weren't hiding it, but
why were they using those things rather than saying Admiral Mark Norman? It's similar to what Ontarians remember from the gas plant when the Liberals used code words to hide disclosure. It ended Dalton McGuinty's career. So the same people that were involved in that are here in Ottawa, Vashi, and it's been concerned.
Total dog whistle, and this is proof positive of the way that the Conservatives want to politicize the court and the criminal justice system. They bring motions onto the floor of the House of Commons. They try to get disclosure of fundamental facts in the House of Commons instead of respecting the independent court system.
And I take your point, Mr. Mendocino, but Ms. Hennon, I know you're referring to Ms. Hennon, and she did say there was no political interference, but she did also make sure that she pointed out the degree to which your government was involved in these proceedings, and she was not insinuating that it was free of any political involvement. Mr. Angus, go ahead, yeah.
They were telling, the government lawyers were telling what could be said and what couldn't be said. Now, the Liberals say this is about national security and solicitor-client privilege, but this stems from what happened at Cabinet about interference in a political contract to help friends. And so...
But look, it wasn't the government who decided to go ahead with the investigation. It was the RCMP. It wasn't the government who pressed charges. It was the prosecution.
But the issue is, about getting to the bottom of this, is that we have lawyers for the Government of Canada deciding what documents will be turned over following, Mr. Wernick's investigation, deciding telling witnesses what can be said and what couldn't be said. Mr. Norman was up against the power of the state from the get-go over whether or not he actually stood up on an issue of integrity, which was about Liberals interfering in a lucrative contract. That is, to me, an unacceptable situation. So I am glad that the Director of Public Prosecutions withdrew the charges. I never had a doubt that those charges would be withdrawn, because when you watched how this case unfolded, it was clear they did not have the evidence. And having Andrew Leslie step forward, stepping down, as a star
Although he
Liberal.
won't confirm anything that's being reported. He
Well,
didn't say
but he's willing to testify.
He is leaving.
Willing to testify is unprecedented, that a Liberal MP, former general, would be there with the defendant this morning to hug him and say, you were right all along. So I think Canadians can judge for themselves by that.
Okay, I'm out of time.
Well,
so
I would just say that you've seen
Yeah, quickly, Mr. Mendocino.
There's a lot of insinuation there that goes far further than anything that you heard from Mary Hennon today, as well as the Director of Public Prosecution.
Okay, I hate to cut the party short, but I have to.
Committing to an inquiry.
Thank you very much to all three of you. Thanks to Mr. Mendocino, Mr. O'Toole, and Mr. Angus. What does today's decision mean for the Vice-Admiral, and what exactly led the Crown to its decision? Earlier, I spoke with Lawrence Greenspan, a criminal defense lawyer at Greenspan Granger Hill. He's also representing Senator Mike Duffy in a lawsuit over Duffy's suspension from the Senate. Hello, Mr. Greenspan.
Hello.
Nice to see you. I appreciate your time today, helping us sort of understand the legal part of all of this. Let's start with the actual action taken today. So the charges were stayed. Can you explain the difference? What does stayed mean versus just withdrawing them completely?
Well, the stay that was entered is something that the Crown is entitled to do by virtue of statute, by virtue of their position as the Crown. The problem with a stay versus a withdrawal is that at any time in the next year, the Crown can reinstitute these same criminal proceedings against Vice-Admiral Norman. With a withdrawal, that's it. They're done. So the question I think that should be asked is, why are they leaving this sword of Damocles hanging over Vice-Admiral Norman's head for the next year? Why not, if you've got new evidence that shows that there's no prospect of conviction, why not just withdraw the charges?
Why might they not?
No idea.
Hard to tell.
It's hard to tell,
It's at
but
their
certainly
discretion, right?
It's at their discretion. But certainly, if they wanted to clean the slate for Vice-Admiral Norman and make clear the fact that he was being exculpated, that he was being cleared of any wrongdoing, what they should have done was withdraw the charges.
Their comments after also put a kind of question mark over that idea. The lead prosecutor said that Norman's actions were inappropriate and secretive, but that doesn't mean a crime was committed. Inappropriate, this is a quote, does not mean criminal. What did you think of that?
Well, my first reaction to that is the only thing that's inappropriate is those comments. Those comments are highly inappropriate. When the Crown is staying the charges against an individual because they have acquired new evidence, which makes it clear that they are not going to be able to proceed to a criminal trial, the last thing the Crown should be doing is saying, well, it wasn't criminal, but it was inappropriate. My goodness.
Is that odd?
Extremely odd, and worse than that, it's highly unfair. I mean, you've charged this man very publicly with a breach of trust. You've effectively stained his reputation forever. And when you walk into court, you say, look, we're staying the charges, but, it wasn't criminal, but it was inappropriate. I think that comment is highly inappropriate, and it's not consistent at all with an attempt by the Crown to make whole Vice-Admiral Norman and his reputation.
Does it open them up or some kind of action up for a civil suit, for example?
Well, civil
work?
action in a case like this, I mean, the first thing you have to find out is what was the evidence that was produced that convinced the Crown that they shouldn't proceed any further. And then the second question after that is, well, how come the RCMP didn't get a hold of that evidence? How come it came from the defense and other third parties? That, the RCMP has a job to do, and it's to complete a full and fair investigation of the individual before they're charged. So now you've got Vice-Admiral being charged very publicly. The damage to his reputation, I would argue, is permanent in the sense that it's all on the internet, available as soon as you Google his name. And you have a Crown walking in saying, we're staying the charges, but, you know, wink, wink, his actions were inappropriate. I think that is a very, very unfair way to put it before the public as far as Vice-Admiral Norman is concerned.
When you look at the range of options available to Mr. Norman now, what might they be?
Well, certainly
for recourse.
Appreciate the fact that the defense minister has announced that they're going to pick up the lion's share of his legal fees, and I think that's a good start. But there has to be some consideration of the fact that he and his family have been put through criminal prosecution, very public, in which his reputation was, I would argue, permanently tarnished. And there has to be some compensation, if there can be, for that. And at the very least, recognition that what he was put through was unfair. And it's hardly undone by the Crown saying his actions were inappropriate.
Can I ask you to dig a little deeper? You mentioned the reasons provided for the stay, and you know, as someone who doesn't have a legal background, when I read them, they were one part of them in particular was confusing to me. It says, after reviewing, this is a statement from the public prosecutor, for further evidence provided to the prosecution, some from applications for records that were not part of the investigation file, third-party records, and some volunteered by the defense. What does that mean, not part of the investigation file and third-party records?
Well, in any of these criminal proceedings, there are pretrial applications or motions. And what happens during those pretrial applications is the defense attempts to access records that are in the hands of third parties or other people. They try to access those records as a way of saying, look, we believe that the contents of those records are going to help us in pursuing a defense for this person whose liberty is at stake. The court then looks at these pretrial applications and says, well, and it's a very difficult argument to make for defense counsel, because really what we're saying is those records, even though we haven't seen them, are relevant to our defense. And we're asked to stand on one leg and argue the relevance of records that we haven't seen. We do this on a regular basis, sadly. But in this case, what they're referring to is there were certain materials filed by the defense in support of their application to get those third-party records, which were not in the knowledge of the RCMP and wasn't part of their investigation. And it's that kind of evidence that came to their attention during the pretrial motions and in which they rely in entering the stay today.
And is there any way of the public ever finding out what that material was? Because Ms. Hennon was asked frequently, you know, what is this new stuff? We want to know as the media, right? And she would not disclose it.
Yeah, well, she's entirely doing her job and not able to disclose it. But the applications were pending before the court, and the court was going to be, you know, ruling one way or the other. Yes, you have to disclose those third-party records to the defense. Fortunately, we still have the principle that where a person's liberty is at stake and their defense is up for grabs, that third-party records have to be produced. And in this case, by virtue of the stay, those records may never be produced.
There is a political conversation obviously happening around this case, and we'll be talking about it throughout the show. But Ms. Hennon made the point that this is evidence, that this shows the system does work, that it is in fact free from political interference, ultimately by the Crown, with making the decision to withdraw these charges based on the evidence that was put before them. Do you agree?
Well, you know, I guess if Shakespeare were here, he might say, methinks thou dost protest too much. Everybody seemed to be tripping over themselves to say, oh, there was no political interference here. I don't know otherwise, but I'm certain you and your colleagues will continue to dig in that direction, as you should, to assure the Canadian public that there was no political interference at any level. I'm not aware of any, but you guys are doing your job, I'm sure, by looking into this, and we'll find out, I'm sure, if it was otherwise.
Okay, I'll leave it there. Thank you very much, Mr. Greenspan. Really appreciate your time today.
Sure.
Chief of Defense Staff General Jonathan Vance issued a statement on this last hour saying, in part, Vice-Admiral Norman and I will be discussing his return to regular duty at the earliest opportunity. This decision ends court proceedings that have been a long and difficult process for Vice-Admiral Norman, his family, and for the Canadian Armed Forces. The statement goes on to say, we have missed Vice-Admiral Norman a great deal, and I look forward to welcome him back to work as soon as possible. For more reaction to today's decision, I'm joined by retired Vice Admiral Bruce McLean, who served as the 30th Commander of the Canadian Navy. Hello, nice to see you. Thank you for being here. I appreciate it.
Thank you for the invite.
What is your reaction to the news that the charge was stayed today?
Absolutely delighted. I think this is a great day for Mark Norman. He's a man of integrity. He stood his ground throughout this long and arduous period. He suffered a great deal. His family suffered a great deal, but he never lost sight of the aim, in his case, to show that he was completely faultless in this particular situation. And I think he has done that and has, the difficulty in going through something like this must be almost unimaginable for most of us.
Yeah, you were watching that video saying, can you imagine? Can
you imagine, indeed. And so for his family and the harm and the difficulties, so there would be unquestionably a great deal of stress within that family unit and amongst friends. It's also difficult for the Canadian Forces, both people at high ranks and lower ranks, to see what's actually happening in their institution. So there's been a great deal of harm done in this particular case, and I don't think we should underestimate that particular challenge. Personal harm, financial harm, because of course we also realize that Mark Norman had to fund this completely himself. And so it has been very, very difficult. I wonder if after all this has happened, whether or not there will be the accountability and responsibility within the institutions to offer Admiral Norman a well-deserved apology for what has happened.
What do you see as accountability? Is it that apology? Is it, I mean, Minister Sajjan said that they pay his legal bills today. They have not said if there's a cap to that. They have not said if they'd go beyond that. What do you think the line of accountability is?
I think the accountability really has to be looked at in a couple of ways. Yes, there is financial remuneration. They've already alluded to the fact that some of the legal costs will be paid. Presumably all the legal costs will be paid. But I think there's a much more important aspect. When you're a naval officer or an Army officer or an Air Force officer, it's this issue of integrity and personal trust and public trust. You are at the highest level within our organization. And for that to be diminished or thrown out, and to have folks within the organization disputing your particular credibility for over 2.5 years it's again, unimaginable.
What do you think the broader implications for the armed forces are? You touched on it, and you said, you know, this had a sort of an impact on the institution. Mm-hmm. What do you think that impact is?
It was huge. I'm hopeful that today is a turning point, and that things will be made good again, not only for Mark Norman but for the institution as well. You know, you have to remember that as the commander of the Navy or the Army or the Air Force or the Vice Chief, your responsibilities are enormous for this country of ours. The job of any military commander in the procurement business is to get the right stuff at the right time. And what we really saw was a very complex issue, really a very complex issue which was hamstrung by a change in government, in my view. And so what was really a sole source contract, and you can argue whether that was proper or not, but that indeed is what we had. And we were down to the point where really we were talking about crossing the T's and dotting the I's. But that pause was a very significant feature which could have caused the disruption, if not the cancellation of that entire program. In that case, Mark Norman, as the commander of the Navy, as a custodian providing the kind of advice that the government needs, would have lost a very valuable asset as part of the force organization within the Navy.
Does that speak to what may have been happening? And I think that's sort of at the back end. Today we're focused on politics and what's happened with the staying of the charge, but the idea that there was some level of involvement, and the Crown even today called it inappropriate. Obviously, Vice-Admiral Norman insists that it was not. But can you tell us, from somebody who's been on the other side, what that involvement, when it comes to procurement, in the example we're talking about here, might look like?
Within the context of procurement, we are always chasing few resources. And it's not to say that the Army, the Navy, the Air Force are against each other, but the reality is we generally can only afford one big project at one time. It'd be like 3 hungry dogs going after one bone, ostensibly. It's really challenging, and you have to have your arms up. That's the nature of the business at the top end. This is defined by, of course, rules within the government, but those rules are there to ensure that we not only get the right stuff, but things are done in a proper manner. I did not see anything in my judgment which suggested that Admiral Norman, for this breach of trust, had actually done something which was unusual or amiss. I mean, we have not seen that.
So that information coming to light, like, I mean, what they had alleged, and obviously the charges stayed, so I want to be fair about that, was that he leaked that information, for example, to members of the media or to the company that was involved.
Again, I think the government has to use its discretion. I also was in the Privy Council office for a time in my in one of my senior positions. It's very, very important to figure out exactly where things are going to go, and to ensure that the option that you take is going to lead to the right solution. If you get that wrong, it's very hard to change track if you're a government. Maybe the next generation, but it's very, very challenging to do so. So you want to get that right. And I'm not sure that in this particular case, don't forget the PCO, Privy Council Office, had this information and dealt with it for almost a year before they then moved it to the RCMP. And of course, the RCMP then moves that to the prosecution. And then it goes to trial. That's 2.5 years altogether. You lose control once you pass that off. And there may be other ways to have dealt with that particular situation without necessarily going to trial. And indeed, the threshold for this particular charge was incredibly high. And it seemed, to me at least, to be a bit of a head scratcher from the get-go. I really couldn't understand, and I'm not a lawyer, but how they were going to get there.
Vice-Admiral Norman says he has a story to tell and that he will be telling it in the coming days. What do you imagine he has to say?
Well, I think he's going to probably take us through what he was thinking, when he was thinking it, why he did what he did, what was the end game as he saw it, what were the risks involved, and if he has a story to tell, and if he can tell it in a credible and a truthful way, then I think Canadians will understand that this probably should never have got to where it got to.
What do you think happens now as far as his own future? He says he wants to be reinstated. We read the statement from General Vance, who said that he will return to work. There was no mention specifically at what position. What do you think is logistically possible?
Well, of course, he was suspended with pay, so that's a starting point. I suppose in a theoretical sense, if this had only gone on for a few months, and that position, his vice chief's position, was left open, it has now been filled. It's very difficult to just sort of insert an individual at that level at this particular time. So that's a negotiation. That's a discussion between the chief and Admiral Norman and others in terms of how we make things right for Admiral Norman. But there's no question, this has been a very, very challenging time, and at the end of the day, he has been exonerated.
He sure has. All right, thank you, Vice Admiral McLean. I really appreciate your time today.
Thank you.
I have an important story to tell that Canadians will want and need to hear. It is my intention in the coming days to tell that story, not to lay blame, but to ensure that we all learn from this experience.
Vice-Admiral Mark Norman spoke there to reporters this afternoon after the case against him was stayed. Norman was charged with 1 count of breach of trust related to an information leak about shipbuilding contract. Today, more than a year after the charge was laid, the Crown abandoned the case. Why? And what happens next? It's time for the Power Panel. In Toronto, Amanda Alvaro of Pomp and Circumstance. Here with me in Summa Strategies' Tim Powers, Kathleen Monk of the Ernst Liff Strategy Group, Chris Hall, host of CBC Radio's The House, and CBC senior reporter Murray Brewster. Hi, everybody. Nice to see you.
Hi.
Murray, I've got to start with you because you followed this trial day in, day out. You were there, of course, for today's revelation.
Yes.
Explain to us what you think is most important for viewers to know about what transpired.
The most important information that we got today was that the Crown was given evidence by the defense. And it is evidence that was dug up by Admiral Norman's defense team. And it is evidence that swayed them to thinking we just can't continue with this case. But what that evidence is, they didn't tell us. And neither the Crown nor the defense would let us know exactly what was happening.
Do you have any idea what it is?
Oh, I've got a few tantalizing clues, but I still have some more journalism to do.
Okay, well, we'll await that. Chris, let's talk a bit about some of the larger political issues here, because this is a sort of complicated case at first, but really he was accused of leaking secret information, basically. And we hear the opposition saying that this was, there was political interference from the beginning. We heard Marie Henein and the Director of Public Prosecution both say today that no, there was no political interference, but also this insinuation that there was some kind of involvement.
Yeah, there's no political interference in the decision to charge, she said, or in the decision in which the charges were withdrawn. But let's look at the broader context here. There was an attempt, a long and continuous attempt by the government to prevent documents from being released. The defense sought and had to go to court to get, including a claim that a memo prepared by the former clerk of the Privy Council, Michael Wernick, was solicitor-client privilege, when we all know that Michael Wernick wasn't a lawyer. So these are the kinds of things that I think the opposition is up against here, and they believe that there's an opportunity to drive home the point. After SNC-Lavalin, this is a government that will not tolerate people who are releasing information that is contrary to what they want out there, who believe that, particularly in a Conservatives' case, that the government deliberately tried to destroy the reputation and the career of Mark Norman. That's what they were saying in the House of Commons today. And all we got back from the Liberals, from Justice Minister David Lametti and from Harjit Sajjan, the Defence Minister, is that there was no interference in the prosecution. So there are lots of questions still to ask about why this unfolded the way it did and what the information was that the government really didn't want to be released publicly.
I just want to be clear, because the office of David Lametti released a statement saying this is not an Attorney General of Canada prosecution. The breach of trust charges were brought under a section of the Criminal Code which is administered by the province. Murray's
well, I mean, so it wasn't a federal prosecution; it was a provincial prosecution. So an attempt to transfer it over and the blame over to the province. I mean, come on.
Okay, I want to play a clip from I want to bring, of course, Amanda, Kathleen, and Tim into the conversation. I just want to play a clip from Marie Henein, the lawyer for Mark Norman today. She's talking about some of the political implications of this.
They are not only the people who decided whether or not to assert cabinet confidence and then a last-minute switch to public interest privilege, and are not only the holders of the documents, but were also counseling witnesses as to what they could and could not say. And I want to make it very clear that we, the defense, had to bring this motion at great expense to Vice-Admiral Norman to get at those records. Neither we, and here's the important part, nor the prosecution were given access to those documents. And the people that were standing in the way of that full disclosure is obviously the government, who had access to them, had those third-party records, and was taking the positions that you all heard they were taking in court.
Amanda, to what degree does the federal government wear this?
Well, I don't know. I mean, I think that for the most part, it feels like, obviously we're talking about the story today and it's a big day, but I also think that there were some important things that were said today. The fact that both the defense and the Crown talked about no political interference, not at the time of charging, not in the decision to stay. That's an important point that obviously the government is going to try to drive home, despite the feigned outrage by the Conservatives day in and day out. I thought it was interesting today, if you watch the exchange in the House, you watched Lisa Raitt on behalf of the Conservatives talk about, and it had a lot of shades of SNC-Lavalin, this idea that how much outrage she had at the alleged political interference when it was related to SNC-Lavalin. And then at the same time today, she talked about the fact that Mark Norman had to defend himself over 2 years while the government sat back and didn't interfere. And it's this kind of hypocrisy in their argument that I find really disturbing and really difficult, because it not only undermines our public institutions, but I think it also really undermines people's faith in those public institutions. Because if you take what they say at face value, then you're deciding that the public prosecution is either, has a political agency, or they're corrupt, or they're lying, and none of those things are true.
I think you can also look at it this way, and I think this is an entirely fair argument. I think it's been made by many people, whether they be conservative or not, that Mark Norman has lost 2 years of service. He's not been able to work for 2 years. He's had to defend himself against some pretty serious charges. And for a person like Mr. Norman, for any person for that matter, but whose career has been in the military, who's been serving Canadians, who put such a high premium on integrity, that's awful. That is awful. So for Lisa Raitt to comment on that as she did, I think that's fine. I think as you showed in that clip of Marie Henein that you played, the argument is going to move to, what were you hiding? May have been nothing, but clearly you didn't want to share something. And the fact that you didn't share it and are not likely going to share it now is going to lead the political narrative down the path that something was wrong here, something was askew. The only people who can fix that are the government. Are they going to do it? Now, that's not to say they didn't get a bit of a win today. Not having a trial during the election, for sure, is a win. But this hasn't gone away. And the final point, sorry, Murray, I see you want to talk, that they were going to make.
You got time, that's okay.
Is also, what is Mark Norman going to say? He says he's going to speak. Yeah. Again, he's a man of integrity. What is the case, though, he's going to lay out? How will that impact the government?
Well, the only thing I want to do is just correct the record for a second. Marie Henein did not say that there was no political interference. What she did today was dial back the rhetoric, which we have seen in court documents, which we have seen in her statements in court. What both her and Admiral Norman were very careful to say was that there was an institutional bias that led to this prosecution. That's very important because at that point in time, who is in charge of the institution? The current government.
My understanding of her statement, and correct me if I'm wrong, was that there was no political interference in the decision to lay the charge or to withdraw the charge, but that there was political involvement, her allegation, political involvement in the steps that led up to that and in the midst of the pretrial in withholding that information.
Well, correct. She didn't like retract everything that she had said in court. What she did is she just dialed it back.
Yeah. I don't know. I kind of tend to agree with Tim that, certainly the Liberals avoided some bad news today by the staying happening. They're not going to have this trial happen on as you've said before, on the eve of the election. But they're not getting any good news because it's still going to hang over them. And the comparison with SNC is so acute, where again, it looks like, at least perception-wise, that the Liberals are doing things to help their corporate friends, right? And there are many actors who have left, politics that could have been drawn into this trial, like for instance Bryson, like Butts could have been drawn, but even Wernick could have been drawn with this blacked out, I think 60-page memo that he was. I think the evidence that this wasn't a good news story for the Liberals today is that the Prime Minister, who is committed to coming to question period every Wednesday for question time, didn't show today, right? Because those hard questions were being asked. We know that it's not just, and it's wider than just politics, right? The defense community, both those folks at D&D, the public servants, and also the industry, the manufacturing side, have thought for a very, very long time that Vice-Admiral Norman was a man of great integrity and always thought this was political posturing the whole time.
But Vashi, really the most telling thing about how concerned the government are about all of this, geez, Harjit Sajjan almost ran over the courthouse with a check for the legal fees. When does, you three have covered court cases, that doesn't happen like that. I mean, they said right away, even Admiral Norman did not know the government was going to do that. The government should do that, but I think that speaks to the desire that the government want to earn some goodwill out of this now and not be tattooed. Yeah, maybe. I think it's pretty late. It's how much are they going to compensate him? It's the bigger question.
To be fair, though, Amanda does have a point that, if you're going to allege that there was, that the DPP was the hero in SNC and withstood political interference, it's hard to say that that it happened the reverse way this time. And that was some of the Conservatives' criticism today.
The DPP acted on evidence there.
But interesting, in the SNC case, it was almost a little bit more removed, right? The allegation was it was on the minister, right? Now it's right in the core. The allegation has been that the PCO, PMO were directing and coordinating this.
But the point is
quickly, we get started.
The Conservatives in particular use the argument conveniently, which way or another, in order to support a political or a partisan point, versus respecting both the job of our public institutions and how people perceive them to be. It's, the police make the decision to charge. The Crown makes the decision to take something to trial. when we start to confuse
the government made the
matter
decision not to produce the documents.
Might have a different view on that too, based
No,
on
but
her
I mean,
experience.
Amanda's right. In
Political institutions, and I think it's really unfair to kind of put it out there, this idea that the government had involved. This government did not have involvement in the decision to take those actions. Those actions are completely independent, and we want them to be. We want our institutions to be totally independent.
And one of the ironies of this is that, given the fact the charges have been withdrawn, these allegations will continue to hang out there, and the evidence of either being political interference or no political interference is not going to come to light.
Right.
Well, nothing.
It's not
just
going to
saying
be tested in
that
court.
there are still a lot of questions to answer, and if I know Murray Brewster, they're going to be asked. And well, we are awaiting this. In the meantime, to Amanda's point, whatever the real facts are, there is a bludgeon now that has been handed to both the New Democrats and the Conservatives to be able to push away at the erosion of the credibility of this government when it comes to dealing with people that they perceive to be opponents.
Hi, I'm Vashi Kapellos, host of Power in Politics. See more of our show by subscribing to the CBC News channel or click the link for another video. Thanks for watching.